My name is Chitakule Fred, a student at Cavendish University, Uganda, Faculty of Law, Bachelor of Laws, year 2015. I'm going to represent a case in the Republic of Uganda, in the High Court of Uganda at Kampala, Commercial Division, civil suit number 0752 of 2019. The case is in between Chandian Kumar, being the plaintiff, versus Majok John, being the defendant, before Honorable Lady Justice Abinyo, the judgment goes. The introduction. This plaintiff brought this suit against the defendant for breach of contract of sale of goods, seeking the following reliefs: a declaration for breach of contract and the orders of general damages, interests and costs of the suit. Facts. The plaintiff's brief facts giving rise to the cause of action against the defendant are that on the first day of March 2018, the plaintiff and the defendant executed a sale of goods agreement in which the plaintiff sold to the defendant 2.296 boxes of liquor at a total consideration of 41.328 United States dollar. However, to date, the defendant, without any justification, refused to pay the plaintiffs the outstanding balance of 24.28 US dollar, despite repeated reminders by the plaintiff that the defendant did not avail to the plaintiff the security under clause 6 of the sale of agreement, and as a result, the plaintiff has suffered damages. The defendant did not file any defense, and an interlocutory judgment was entered. The case was set for formal proof, hence this judgment. A representation. The plaintiff was represented by counsel Paul Sewunya of Mrs. Paul Sewunya and Company Advocates. Issues for determination. During the scheduling proceedings, issues were agreed upon for court's determination. However, in accordance with Rule 5, subsection 1 of Order 15 of the Civil Procedure Rules, sections 171, subsection 1, this court decided to amend the issues as follows. Issue 1, whether there was a breach of contract. Issue 2, what are the available remedies? Evidence. Counsel for the plaintiff complied with the court's directive to file witness statement, which was adopted on record as the plaintiff's evidence in chief. The said evidence will be evaluated hereunder. Issue number 1, whether there was a breach of contract. In the instant case, it was the plaintiff's evidence that on the first day of March 2018, the plaintiff and the defendant executed a sale of goods agreement, PE1, in which the plaintiff sold to defendant 2.296 boxes of liquor at a total consideration of 41.32 United States dollars. That the defendant made a part payment of 17.100 United States dollars, 17,000 100 only and undertook to pay the balance of 24.28 US dollars within a period of 30 days from the date of signing the agreement, that despite repeated reminders by the plaintiff, to date, the defendant has, without any justification, refused to pay the plaintiff the outstanding balance of 24.228 US dollars. Under clause 9 of the agreement, the defendant undertook to give the plaintiff a 10-feet container full of wheat, together with the document relating to the said container as security for payment of the balance of the purchase price of 24.228 US dollar. That this has caused the plaintiff financial loss in the business and inconveniences for which the plaintiff claims damages. Counsel for the plaintiff reiterated the plaintiff's evidence as above and submitted that under Section 61 of the Contract Act 2010, the plaintiff is entitled to compensate from the defendant for breach of contract. Decision. The court have established that parties are bound by the terms of the contract that they execute. A breach, therefore, occurs where that which is complained of is a breach of duty arising out of the obligation undertaken under the contract. You can see the Court of Appeal decision in Bahanga versus School Outfitters, Uganda Limited, 2000. East Africa Law Report, page 20, and the Barclays Bank of Uganda Limited versus Howard Bakoja, High Court, suit number 53 of 2011, and the Nakawa Trading Company Limited versus Coffee Marketing Board in the High Court, suit number 137 of 1991, as it was cited by counsel for the plaintiff. The preposition of the law is that whoever alleges a given fact and desires the court to give judgment on any legal right or liability depend on the existence of any fact, has the burden of proof that fact, unless it is provided by law that the proof of that fact shall lie on another person. See section 101 and 103 of the Evidence Act, Cap 6, and Jovile Barugahari versus Anthony General in the Civil Appeal number 28 of 1993, decided the case in the Kampala Law Reports, page number 190. It is settled law that failure to file a defense raises a presumption that the plaintiff's story must be accepted as the truth or a constructive admission of the claim made in the plaint. See United Building Services Limited versus Yafes Mozilla TA Quick Stick Builders and Company number 154 of 2005. It is noteworthy that the defendant refused and or ignored to file a defense. However, the burden of proof still lies with the plaintiff to prove his or her case on the balance of probabilities, even when the case was heard on formal proof. See Ewadra Emmanuel versus Specon Services Limited, number 0022 of 2015. Smith versus Auto Electro Services Limited of 1951, page 24, Kampala Law Reports, page 22, and Hajj Aswan Mutekanga versus Equator Growers Uganda Limited, number 7 of 1995, cited by counsel for the plaintiff, in which the court held that where an interlocutory judgment has been entered in favor of the plaintiff, the question is liability of the defendant is no longer an issue. What is in issue is the assessment of the quantum of damages. I have taken into consideration the evidence adduced above by the plaintiff to find that the plaintiff has discharged the evidence burden of proof to the required standard and proved that the defendant failed and or refused to pay the outstanding balance of 24.228 United States dollars only. For the foregoing reason, this issue is answered in the affirmative. Issue number 2. What are the available remedies? This court have 4 issues, one above in the affirmative. Further, finds as follows. Section 61 of subsection 1 of the Contract Act 2010 provides for compensation to a party who has suffered any loss or damages as a result of breach of contract. In the given circumstances of this case, I find that the plaintiff is entitled to the outstanding balance of 24.228 United States dollars only from the defendant for breach of contract. General damages are the direct, natural, or probable consequences of the wrongful act complained of, and includes damages for pain, suffering, inconveniences, and anticipated future loss. See Stones versus Hutchinson, decided case of 1905 in the appeal case, page number 515. It is settled law that an award of general damages is granted at the discretion of court. See Crown Beverages Limited versus Sedu Edward in the civil appeal number 1 of 2005, and Uganda Commercial Bank versus Chigoze, decided case of 2002, 1 East African Law Report, page 305. Following the guidance in Uganda Commercial Bank versus Chigoze Supra on the factors to be considered by the court when assessing the quantum of general damages, which are as follows: the value of the subject matter, the economic inconveniences that the plaintiff may have been put through, and the nature and extent of the injury suffered. In the instant case, the plaintiff has proved to the satisfaction of this court that the defendant's failure to pay has caused him financial loss. and inconveniences for which the defendant is held liable in general damages. In the result, this court finds that the plaintiff is entitled to 4,800 United States dollars only in general damages, considering the economic loss and inconveniences occasioned by the defendant to the plaintiff's business. The courts have decided in a plethora of cases that where no interest rate has been provided, the rate is fixed at the discretion of the court. See Crescent Transportation Company Limited versus Big Technical Services Limited, CACA 25 of 2000, cited with approval in Westgate Warren versus Kiza Bin in the High Court, a civil suit number 220 of 2015, relied upon by counsel for the plaintiff in support of his submissions. The court has taken into account the fact that the defendant has deprived the plaintiff of the money since 2018 and finds that an award of interest at the rate of 20% per annum on the principal sum above is sufficient from the date of filing this suit until payment in full. In addition, an award of interest in general damages at the rate of 6% per annum for the date of judgment until payment in full will suffice. In respect of the costs, Section 27, subsection 1 of the Civil Procedure Act, Cap 71 provides as follows: subject to such conditions and limitations as may be prescribed, and to the provision of any law for the time being in force, the costs of and incident to all suit shall be in the direction of the court of judge, and the court of judge shall have full power to determine by whom and out of what property and to what extent those costs are to be paid, and to give all necessary directions for the purposes aforesaid. Taking into consideration the above provision on costs, and that cost follows the evidence unless for justified reason the court otherwise orders, see Section 27, subsection 2 of the Civil Procedure Act, Cap 71, and the decision in Uganda Development Bank versus Uganda Construction Company Limited of 1981, where Justice Manini, as he then was, held that a successful party can only be denied the costs if it's proved that but for his or her conduct the action would not have been brought. The cost will follow the event where the party succeeds in the main purpose of the suit. I find no reason to deny the plaintiff costs, and accordingly the plaintiff is awarded costs of his suit. Judgment is hereby entered for the plaintiff against the defendant in the following terms: 1. A declaration that the defendant breached the contract. 2. The plaintiff is entitled to 24.28 United States dollar only. 3. General damages of for 4,800 United States dollars only for interest on to above at the rate of 20% per annum from the date of filing this suit until payment in full. 5. Interests on 3 above at a rate of 6% annum from the date of judgment until payment in full. Then costs of the suit dated and delivered electronically. This date 12th day of September 2023. Susan Abinyo.